Every year in the United States, courts revisit the boundaries of the Fourth Amendment, the constitutional protection against unreasonable searches and seizures. Most of the time, those rulings quietly reshape how law enforcement operates, without making national headlines. But occasionally, a decision emerges that directly affects something deeply personal: your home. Recently, a court ruling clarified circumstances under which police may enter a private residence without a traditional warrant. The legal reasoning behind it is complex, rooted in precedent, and grounded in constitutional interpretation. But here's the question: does this ruling simply clarify existing law, or does it expand police authority in a way that challenges long-standing expectations of privacy? Let me know your answer in the comments below. To understand the significance of this ruling, we must begin with the foundation: the Fourth Amendment to the United States Constitution. It states that people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and that warrants shall not be issued without probable cause. For over 2 centuries, courts have interpreted this language, balancing two competing interests: individual privacy and public safety. According to long-standing Supreme Court precedent, warrantless searches inside a home are presumptively unreasonable. The United States Supreme Court has repeatedly emphasized that physical entry into the home is the chief evil the Fourth Amendment was designed to prevent. However, the court has also recognized specific exceptions where a warrant is not required. One of the most cited precedents is Payton v. New York, decided in 1980. In that case, the Supreme Court held that police may not enter a home without a warrant to make a routine felony arrest, absent exigent circumstances. The decision reinforced the constitutional principle that the home holds a special status in American law. But over time, courts have carved out exceptions. These include exigent circumstances, consent, the emergency aid doctrine, hot pursuit of a fleeing suspect, and certain community caretaking functions. The recent ruling at the center of today's discussion did not invent a new exception from scratch. Instead, it addressed how existing exceptions apply under modern conditions, particularly when officers claim immediate necessity. According to official court records, the case began when officers responded to a reported disturbance involving potential violence. Upon arrival, they encountered circumstances they described as urgent and potentially dangerous. Without obtaining a warrant, officers entered the residence. The occupant later challenged that entry in court, arguing that the warrantless search violated Fourth Amendment protections. The plaintiff alleged that no true emergency existed and that officers had sufficient time to secure a warrant. The department, in its defense, stated that the officers acted within established legal exceptions. They argued that the situation met the standard for exigent circumstances, specifically the need to prevent imminent harm or destruction of evidence. The case moved through lower courts, where judges examined body camera footage, dispatch logs, and officer testimony. The legal question was not whether officers had good intentions. Instead, the issue centered on whether the facts, viewed objectively, justified immediate entry without judicial authorization. In its opinion, the court referenced prior Supreme Court rulings, including Brigham City v. Stewart, which permits warrantless entry when officers have an objectively reasonable basis to believe someone inside is seriously injured or imminently threatened with injury. The court also cited Kentucky v. King, which addresses situations where police-created exigency may invalidate a warrantless entry. One interpretation of the new ruling is that it reaffirms established doctrine rather than expanding police power. The court emphasized that the reasonableness standard remains objective, meaning the subjective intent of officers is less important than whether a reasonable officer would perceive an emergency. Another perspective raised during arguments is that modern policing technologies, including rapid communication systems and digital warrant applications, may reduce the need for immediate entry without judicial oversight. Critics argue that because officers can now obtain electronic warrants in minutes in many jurisdictions, the threshold for exigency should be higher than in past decades. The court, however, noted that constitutional analysis must remain practical. Judges stated that the Fourth Amendment does not require officers to delay action when confronted with immediate risk. At the same time, the ruling stressed that warrantless entry remains the exception, not the rule. Importantly, the decision clarified that generalized suspicion or vague safety concerns are insufficient. Officers must articulate specific, objective facts indicating immediate danger or risk of evidence destruction. This distinction became central to the court's reasoning. According to the written opinion, the totality of circumstances must be evaluated, including the time of day, nature of the reported offense, sounds or statements heard from inside, and observable behavior of occupants. The ruling also addressed the scope of permissible search once inside. Even when entry is justified under exigent circumstances, the search must be limited to addressing the emergency. Officers may not conduct a full evidentiary sweep unrelated to the stated justification. This limitation reflects another core principle of Fourth Amendment jurisprudence. Reasonableness is context-dependent and narrowly tailored. Legal analysts have noted that while the ruling appears narrow, its practical impact could be significant. Law enforcement agencies may view it as affirmation of existing training standards regarding emergency response. Civil liberties advocates, meanwhile, caution that broad interpretation of immediate danger risks erosion of home privacy protections. At its heart, this case illustrates the constant tension between security and liberty, a tension embedded within constitutional law since the nation's founding. To fully appreciate the legal implications, it is important to examine how courts define exigent circumstances. Historically, exigency includes situations involving hot pursuit of a fleeing felon, imminent destruction of evidence, need to prevent escape, and risk of harm to officers or others. The Supreme Court has consistently held that the gravity of the underlying offense matters. Minor offenses generally do not justify warrantless entry, absent clear emergency. In Welsh v. Wisconsin, for example, the court ruled that police could not enter a home without a warrant for a non-criminal traffic offense. The recent ruling reaffirmed that seriousness remains relevant. The court distinguished between violent felony reports and minor infractions, suggesting that the threshold for exigency varies depending on context. Another critical issue examined was whether officers themselves created the emergency. Under Kentucky v. King, police may not rely on exigent circumstances if they unreasonably manufactured the situation through conduct that violates the Fourth Amendment. In this case, the court determined that officers responded to an independent report and did not provoke the conditions leading to entry. This finding proved pivotal. Still, debate continues among legal scholars regarding how broadly such rulings may be applied. Some argue that clear guidance benefits both officers and citizens, reducing ambiguity in high-pressure situations. Others warn that judicial deference to on-scene assessments can unintentionally expand police discretion. It is important to emphasize that this discussion is for informational purposes only and does not constitute legal advice. As we continue examining this decision, the larger constitutional framework remains central. The Fourth Amendment protects against unreasonable searches, not all searches. The meaning of unreasonable evolves through case law, shaped by factual nuances. In practice, courts evaluate three primary factors: whether there was probable cause, whether exigent circumstances existed, and whether the scope of the search remained limited to the emergency. The ruling at issue applied these principles without rewriting them, yet its real-world consequences may depend on how lower courts interpret and apply its reasoning. As technology advances and policing methods evolve, courts face new challenges. Digital evidence, rapid communication, and body-worn cameras all influence judicial review. Transparency tools, such as body camera footage, often provide judges with direct insight into officers' decision-making processes. Supporters of the ruling argue that objective video evidence strengthens accountability while preserving flexibility in emergencies. Critics maintain that constitutional rights should not hinge on split-second interpretations when judicial review is increasingly accessible through electronic warrant systems. And that brings us to a broader question about constitutional balance in the modern era. If obtaining a warrant can sometimes be done in under 15 minutes through digital systems, should courts require officers to attempt that route unless there is an unmistakable threat? Or does imposing such a requirement risk delaying response in situations where seconds matter? The court did not impose a bright-line rule. Instead, it reaffirmed the case-by-case totality of the circumstances analysis. In many ways, that may be the most consequential aspect of the decision. By resisting rigid formulas, the judiciary preserves flexibility, but also leaves room for interpretation. As this ruling circulates among legal professionals and law enforcement agencies, training protocols may adapt. Officers are likely to receive guidance emphasizing articulation, the ability to clearly describe the specific facts that justified immediate entry. Documentation becomes critical. Courts scrutinize not just actions, but explanations. In future litigation, defense attorneys may challenge whether officers truly lack time to seek a warrant. Prosecutors may emphasize observable signs of urgency. The outcome will often depend on precise factual records. Ultimately, this case does not erase the warrant requirement, nor does it grant unlimited authority. It reinforces a long-standing exception while clarifying its contours under present-day conditions. But whether that clarification strengthens constitutional protections or subtly broadens enforcement discretion remains a matter of ongoing debate. And so we return to the central issue. When police cross the threshold of a private home without judicial approval, what standard truly governs that decision? In the next segment, we will examine real-world scenarios where this ruling may apply, compare dissenting judicial opinions in similar cases, and explore how appellate courts nationwide are interpreting the balance between emergency response and constitutional safeguards. Given the legal landscape, do you believe current Fourth Amendment doctrine adequately protects homeowners, or does it leave too much room for interpretation? Share your perspective in the comments and subscribe for continued in-depth legal analysis grounded in verified facts and court precedent. In examining how this ruling may shape future cases, it is important to step back and look at how courts across the country have historically treated warrantless home entries. Appellate courts have long emphasized that the sanctity of the home is a constitutional cornerstone. At the same time, they have recognized that rigid rules cannot account for the unpredictable nature of emergency calls. In multiple circuits, judges have stressed that officers must point to concrete facts, not assumptions, when claiming exigent circumstances. For example, courts have ruled that vague reports of possible trouble are insufficient. However, when officers hear screams, observe visible injuries, or receive credible threats of violence, judicial opinions often lean toward validating immediate action. The recent ruling follows this same analytical pattern. It does not remove the warrant requirement. It does not grant blanket authority. Instead, it reinforces the principle that emergencies are evaluated through an objective lens. The question is not what the officer believed internally, but what a reasonable officer, given the same facts, would have believed at that moment. Legal scholars have pointed out that this objective standard is both a safeguard and a source of debate. On one hand, it prevents courts from relying solely on subjective claims of fear or urgency. On the other hand, it grants judges discretion in determining what counts as reasonable, which can vary depending on interpretation. Another dimension of this issue involves technology. In many jurisdictions today, electronic warrant systems allow officers to contact on-call judges quickly. Digital affidavits can sometimes be submitted within minutes. Critics of broad exigent authority argue that as access to rapid warrants expands, the justification for bypassing judicial review narrows. Supporters of the ruling counter that emergencies rarely unfold in predictable timelines. They argue that officers responding to chaotic or potentially violent scenes cannot always pause to draft affidavits without risking harm. According to this view, constitutional reasonableness must reflect practical realities. Courts have repeatedly affirmed that the Fourth Amendment does not demand perfection from law enforcement, but it does demand accountability. If officers enter a home without a warrant, they must later justify that decision under judicial scrutiny. The burden shifts to the government to demonstrate that the circumstances fit within a recognized exception. One important turning point in the broader jurisprudence came from cases addressing minor offenses. The Supreme Court has signaled that the severity of the suspected crime matters. When the alleged offense is minor and there is no immediate threat, warrantless entry becomes far more difficult to justify. This principle remains intact under the recent ruling. The court also reiterated limits on what officers may do once inside. Entry justified by emergency does not become an open-ended search authority. The scope must remain tied to resolving the emergency itself. If officers observe unrelated evidence in plain view while lawfully present, separate legal standards apply, but the initial entry cannot serve as a pretext for a broad investigatory sweep. Civil liberties organizations have responded to rulings like this by emphasizing vigilance. They argue that clarity in judicial opinions must be accompanied by strict enforcement of limits. Otherwise, incremental expansions of exceptions could gradually weaken privacy protections. Law enforcement representatives, by contrast, often stress that clear standards help officers make lawful decisions under pressure. They contend that ambiguity can place both officers and civilians at risk. The reality may lie somewhere between these positions. Constitutional law evolves not through sweeping declarations, but through incremental interpretation of specific fact patterns. Each case adds detail to the framework. In practical terms, what does this mean for homeowners? First, it reaffirms that the warrant requirement remains the default rule. Police generally must obtain judicial approval before entering a residence. Second, it confirms that true emergencies, those involving immediate risk of harm, destruction of evidence, or escape, may justify temporary suspension of that requirement. Third, it underscores that courts will review those decisions carefully after the fact. For citizens, understanding these principles can be empowering. Knowing that officers must articulate specific objective facts helps clarify what the Constitution protects. For officers, thorough documentation and adherence to training standards remain essential. The broader constitutional question is not new. Since the founding era, American law has wrestled with how to balance liberty and security. The Fourth Amendment emerged from colonial resistance to general warrants and writs of assistance, tools that allowed broad searches without individualized suspicion. Modern jurisprudence seeks to prevent similar overreach while recognizing contemporary challenges. As appellate courts interpret this latest ruling, further clarification may emerge. Some cases may narrow its application based on unique facts. Others may expand its reasoning under different circumstances. Over time, patterns develop, and the doctrine either stabilizes or shifts. What remains constant is judicial oversight. Even when officers act without a warrant, courts serve as the constitutional checkpoint. Evidence obtained unlawfully may be suppressed. Civil lawsuits may follow. Internal departmental reviews may examine policy compliance. This layered accountability system is designed to maintain balance. It is also worth noting that constitutional protections operate alongside state laws, departmental policies, and community expectations. Some states impose stricter standards than federal baseline requirements. Local procedures may require supervisory approval in situations where federal law would not. Because of this complexity, outcomes can vary by jurisdiction. What is deemed reasonable in one factual setting may not be in another. This discussion is for informational purposes only and does not constitute legal advice. Individual situations depend on specific facts and applicable state and federal law. Looking ahead, the conversation surrounding warrantless entry will likely continue as technology, public expectations, and judicial philosophy evolve. Body camera footage, real-time reporting, and digital records increasingly shape how courts evaluate reasonableness. Transparency tools may both support and challenge law enforcement narratives. In the end, the recent ruling serves less as a revolution and more as a reaffirmation. A reminder that constitutional doctrine operates within structured exceptions, carefully defined but continuously interpreted. The home remains a protected space under American law. That principle has not changed. What continues to evolve is how courts interpret urgency, risk, and reasonableness in rapidly unfolding events. And that brings us back to the essential question raised at the beginning of this analysis. When officers step across the threshold of a private residence without a warrant, are they acting within a constitutionally recognized emergency or testing the limits of a foundational safeguard? Given the facts and the legal standards we've discussed, do you believe current Fourth Amendment doctrine strikes the right balance between protecting public safety and preserving the sanctity of the home, or does it leave too much room for interpretation? Share your perspective in the comments below. If you found this legal breakdown informative and fact-focused, subscribe for more in-depth analyses of court rulings, constitutional rights, and the real-world impact of judicial decisions.